Hello everyone, my name is Dhruv. I am an intern at LEXIS and Company. So today we are going to discuss about topic which is development of laws with respect to rape over the period of time, over the period of years. Now talking about this topic generally, so women from centuries and time from the which civilization began have been subjected to very tough living conditions as compared to a man. Now, her voice has been oppressed under the huge pillars of ideologies, or which later formed the establishments of structures of the patriarchal society. These society resulted in more or less and more loss for women. Now, women were often and are now even in this present time also are now often asked just to hold on themselves and suffer the pain in their misery that may come with their in their terms and terms of crime, be it domestic violence, rape, sexual harassment, sexual assault, etc. Now, laws that were governed by the land today were formulated back in the 80s, and they were adopted likewise. After our independence in 1947. Now, since then, we have seen a change in the laws, and we have changed in the ambit of the statutes formulated and also witnessed, and are witnessing the amendments even if the same are required with the changes times. So now we will talk about the major part of this. Now we'll be covering the cases like Nirbhaya gang rape case, and starting with the topic. So women from centuries and centuries and the time from which civilization began always subjected to very tough living conditions, and as we evolved as human, our desire for getting more in terms of power, money and success grew. With this came to need to suppress the other people to which we can feel powerful. Now often this was fulfilled by targeting the physical weaker human, and by our society, if we talk about the weaker human, so it is always considered that women are physically weaker. Now women are often asked to just hold on themselves to suffer their pain, and they may come always in the terms of the sexual or non-sexual crimes also, as we discussed about. So now talking about the rape. So rape was introduced in IPC in 1860, and this was the time when it was defined for the first time. So rape in layman terms is being act of being physically involved with someone without their consent. Now here consent plays a major role, and rape can happen with all the genders. It doesn't about it is not only about women specifically. It can be male, female or transgender. Now the sad part of the topic is that enough cases are there where a male is a victim, but they are not brought to attention. So this brings us to a question, and a very crucial question, that our laws are gender neutral. Now if you know the answer, do discuss it with me. Now talking and moving further onto the topic, so rape can be done by a single person, more than one person, or a group of people, which is also known as gang rape, or by a husband, which is known as marital rape. So marital rape is however not an offence in our country as per law of land, but if we talk about the law, so it is an offense. Now the point is that why rape has been such a matter of discussion, why it is so quoted like this. So after being defined in 1860 in IPC and in section 375, there was a punishment made for the act of sex by a man with a woman against her consent, and it also includes a situation where the consent has been obtained by intoxication, or by obtaining consent, or by putting any pressure for the consent. Now section 376, and this involves the punishment of the doer, whoever commits this offense, whoever ever commits the offense of rape, and it is minimum to 7 years of jail extending up to the life imprisonment. Now the major case laws which should be discussed and should be revised are the Mathura rape case. In this case, as it was recently held, and in this case a Dalit girl was raped by a policeman and in a police station of Maharashtra. So the point is that even the people who are bound to follow law are actually breaking the law. So this case was tried in the session court, where the judge acquitted both the policemen and the court was of conclusion that she had intercourse, but there was no evidence of rape. So the case further went to High Court. The judge revised in the order of acquittal. The Supreme Court in 1978 gave a verdict saying that there were no marks of injuries, which indicates that intercourse was a peaceful affair. This judge was criticized and people demanded change in the existing rape laws. So from this, there was a lead of development in the criminal law, and which added a new section, which was section 114A, and it was added to Evidence Act so that people can found proper evidence. Now this section was added and presumed the absence of consent of prosecution of rape, and was applicable in the custodial rape in cases. In the code section 2, I guess 2228 subclause A, which added to help the conceal of the identity of victim of certain offences, including the offence of rape. So we'll discuss it till here, and in the next video we'll be talking about, was this change sufficient enough? And please share your views on this in the comment section, or you can directly send it. Thank you.